Hi, everybody. I am here with Ami Sanghvi, a really close friend of mine and also client of mine who is an employment attorney. And I wanted to bring her on today because I've noticed that unfortunately, there's a lot of people out there that are losing their jobs and continue to lose their jobs. And as an employer, this is something that I think about a lot in terms of, I want to keep my staff on. I also want to make sure that I'm taking care of them and thinking through things in a proper legal way where I'm protected. I know I was chatting with someone in my business group recently, and they were saying that, they're recommending all business owners to really increase their insurance with regard to, I don't remember the correct word, but letting people go. And so, obviously the best insurance is just making sure that you're doing things right to begin with, and we want to do the right thing. So Ami has a background in really protecting, people of all shapes and colors, from homeless people in New York, and most recently a big passion for protecting, employees. And she's going to talk to us a bit today about the CARES Act and how that can help anyone who's been laid off. And then we're also going to get into some things just in terms of what she's seeing in her work with regard to increases in cases and some different things that are coming up as a result of COVID, and then just as a result of this massive unemployment environment that we're in. So with that, we'll get started. So should we start with CARES?
Yeah, absolutely. Awesome. First, I'll say thank you, Ruth, for having me on. This is lovely to be able to have this conversation, and I certainly appreciate your thoughtfulness that you bring to this from the perspective of an employer, but also just somebody who's sort of living through this very intense and strange moment in time. Just to begin with the CARES Act, most people know that sort of very early in the pandemic, I think it was March or so, Congress passed two very big pieces of legislation. One is called the Ffcra. This is like alphabet soup for even lawyers. But the Ffcra is the Families First Coronavirus Response Act, and that provides for emergency paid sick days as well as paid family leave, which is an expansion to the FMLA. So that's one portion of employees who need to take some time off from work for a COVID-19 related reason. Then specifically for CARES did a few different things, and primarily it created or modified 3 unemployment insurance programs. So the way I like to think about it is it expanded, it extended, and it increased. So the Pandemic Unemployment Assistance Program expanded coverage. And what that really means is it is drawing in people who are unemployed and underemployed because of COVID-19, but not eligible for traditional unemployment insurance. So that you can think about people who don't have a sufficient work history during the last 18 months to qualify for standard UI benefits, and they have become unemployed or underemployed because of COVID-19. And a huge beneficiary of this are gig workers and people who are considered independent contractors who would not, under traditional unemployment insurance programs, be eligible.
Yeah, it's a new thing for my industry, right? Because we're 1099. And so for the first time, real estate agents have actually had access to unemployment. I was wondering with regard to that, if a real estate agent files for unemployment and then they sell a house, does that mean they can no longer, how are they, it's different, like W-2, it's very obvious when you're working versus not. But I think that's one of the reasons why 1099s have been excluded, because we're always working, we're just not always getting paid.
Right. Right. I mean, one of the things that I think the law was careful to do is to say that this is extending to people who are unemployed as well as underemployed. And this notion of underemployed includes a reduction of hours. And I haven't looked at it specifically in terms of sales, but my guess would be you would be able to say, I have experienced some level of underemployment as a result of just not having as much work as I did prior, and therefore I can claim under the PUA for benefits. So that's a big distinction that expands coverage to people who weren't previously eligible.
One of the things a lot of business owners are complaining about not so much in this area, but like in the Midwest where, you know, I have family who actually own, you know, they own a restaurant and stuff. And it seems that some of the maybe unintended consequences are that the unemployment is so high for, you know, that like blue collar workers who, you know, now they don't actually want to go back to work in a restaurant or something like that because they're actually collecting more unemployment. So it seems like there was like something left off for, you know, like, well, if your employer offers you to come back to work, is there, have you heard any talk about revising that, or it's just, it is what it is?
Well, I mean, I think two responses to that. One is, I think that's referring to that third, when I talked about the expansion, the extension, and then the increase. I think that is really drawing in this notion of the increase in benefits. So the Pandemic Unemployment Compensation, the PUC program, basically states that if you have regular unemployment insurance, if you're eligible for that expanded PUA claim, or your extended benefits through the extension, then between March 29th and July 25th, that, you know, you should check that. I think certain states change that end date a little bit, but you'll receive an additional $600 in federal stimulus funds. So generally unemployment insurance is a partnership between the federal and the state government. And so the state government will decide what your weekly benefit amount is based on your base period, and they do that calculation. And then for this window of time, you're going to receive $600 of federal money to supplement what you're receiving in unemployment insurance. But number one, it's limited. So as of right now, and I don't, you know, the news is changing and I try to stay on top of it, I don't know of any current bills that are going through Congress right now that would extend that date beyond July 25th. And then, so that's one thing, it's not forever. And so in terms of a revision, there's an end date. But then the second piece of it is, I do believe you still need to qualify or certify for unemployment insurance. And if I'm not mistaken, one of the certification questions, at least in California, every 2 weeks is, are you ready, willing, and able to go back to work? And have you refused an offer of employment? Mm-hmm. So, you know, I think there, while I appreciate, and I have read the news articles as well about this sort of tension between I'm getting more staying home than I would going back to work and exposing myself to a risk, is there. It's number one, time limited. And number two, I query how sound that analysis would be, given the requirement that states will often have that people not reject an offer of employment if offered.
Yeah, it seems like the employer should just be able to contact them and be like, these are the people who I've offered work to that has returned it, that has refused it, right? And then it'd be like, okay, then they would look into that further, perhaps disqualify that. I mean, it seems like that's not meeting, it's not meeting what was intended to happen there. But when you talked about, you know, potentially maybe some of the reasons that people don't want to return to work is because they don't feel safe. I'm sure you must be dealing with this as well. Do people have to return to work if they're offered employment? And what should employers be thinking about in terms of, you know, maybe even their own risk for exposing their employees to a dangerous environment? Right.
I'll give you the very typical lawyer answer, which is, it depends. And, you know, it's a very complicated question. I'd say if I were to answer it very briefly, in general, if you have a job, you've been working at home for some period of time because of the quarantine orders in your locality or state, and those have been lifted and you have been asked to return to work, it doesn't work to simply say, nope, I don't want to, I'm not comfortable, I'm not coming back. There is a much more of a process that needs to happen. And this is really where employees and employers should, could, and really must work together to have interactive processes and a conversation about what should happen. So there are questions about, why doesn't the person feel safe? Is the employer actually doing what they need to do to provide enough protective gear, if that's the issue, provide enough space between people, if that's the issue? You know, what are the concerns regarding safety? And, you know, there's a whole federal agency that's supposed to be dedicated to ensuring workers'
What if all
safety.
that's there, but maybe I just have a pre-existing condition, or I'm older, or, you know, so I just feel more nervous about my exposure, and I'd rather continue the duties as best I can from home. And then to add it, and I know that a lot of the people who you advocate for, thank you for doing that, is women. And so to add to the further complication, right? Like I have kids at home, and so maybe my work is actually not being, my performance is actually being altered because I'm trying to take care of my kids while I'm trying to do my job, but I don't want to go into the office. And also maybe I can't even afford childcare, right?
Right. Right. So a couple of things. I mean, to start, in terms of if you have a concern about needing to take care of somebody at home, there are, so I sort of glanced over it at the beginning of our conversation, but the Ffcra provided for emergency paid sick days for employees. So that basically entitles a full-time employee to 2 weeks of paid sick leave. So if you're caring for yourself, then
right. But we had like 2 months of kids at home with no school.
Right.
And probably lots more of that coming is my guess.
For sure. And I think that, you know, I'd say my probably best piece of advice is some of this has to be done, but it needs to be done in a fair and consistent manner. So you know, what I would be cautious about are employers sort of making, number one, some assumptions about whose work might be affected more than others. So if you have a woman on your team as well as a man on your team, they both have children at home, but you're going to be a little bit harsher on the woman's performance than you are the man's performance because of some underlying gender stereotyping, then that's something that really would implicate Title VII, which is a protection for people and prevents discrimination on the basis of sex. That's something that employers need to be thoughtful about. Am I evaluating people on the basis of what they're producing in a way that is equal across the board and not bringing in sort of an implicit or explicit bias around who's doing what? So if you're allowing your workers to work remotely, then you're judging sort of what product they're providing. You want to make sure that there are ways to do that that's fair and not benefiting one class of workers over another. So that's one issue. In terms of, I can't go back in, I'm not eligible for any additional leave, sick leave, whatever that might be, I think then the question is, does the employer allow other people to work from home for different reasons? And so again, you can't sort of say you can't work from home because you have childcare needs while this person is going to work from home because they have some other reason for it. So you want to be able to apply some of those policies across the board and evenly, and also be aware of the protections in the law for family leave and paid sick leave for individuals who have to stay home to care for a child. And then also just making certain that that conversation is happening. So for the person who has a pre-existing condition, I know that was one of the questions, or is older, if there is a way to provide that individual with a reasonable accommodation. So, you know, one of the main things to remember is despite COVID-19, despite the economic downturn, the laws are the laws and they have not changed, and protections for employees remain. And so to the extent that an employee is seeking some sort of reasonable accommodation under the ADA for a condition, then they have to go through that process with their employer, just the same as if they were, you know, pre-COVID-19, they were undergoing some treatment that required them to stay home, or they couldn't commute, or they had, you know, needed to work from home for a variety of reasons. That same process exists. Those same laws protect individuals, and employers should continue to employ some of those practices. Now, and a lot of this landscape is changing a lot. So the EEOC, which is the federal agency charged with protecting employees and enforcing the country's federal anti-discrimination laws, and where I worked for the last 10 years, they've been putting out guidance for how employers can ask certain questions during this period of time, because normally you couldn't take someone's temperature when they returned to work. That would be like a impermissible medical inquiry, or you couldn't ask somebody if they've had a COVID-19 test. Whereas right now, in this moment in time, at least during the existence of this pandemic, that is something that employers are permitted to do. And that guidance is changing sort of pretty frequently. Just, I think 2 days ago, the EOC, who had previously said that you can administer a COVID-19 test to employees or require that they have one before they enter the workplace, but you cannot, as of 2 days ago, they've clarified that you cannot require an antibody test, because that would constitute a medical examination under the ADA. And that is, a lot of this is based on changing guidelines or new guidelines that are coming out from the CDC. And so a lot of that landscape is certainly changing. And I think, this is probably a little, I don't know what the word is, maybe naive or maybe too hopeful, but the idea is, I think, truthfully, if people are working with their employers and employers are looking at this from a perspective of trying to ensure that they're doing right by their employees, there are ways to navigate a somewhat complicated situation. But the very, very long answer to your question is, there really is no clear, yep, you can do this, and no, you can't do that. If you feel like you can't go to work because it's not safe, we have to consider the safety considerations. If you feel like you can't go to work because it's, so the first one is if it's not a safe and working environment, there are those concerns. If the second concern is, I don't want to go to work because it's not safe for me because of my pre-existing conditions, then I might need to seek something from a doctor to be able to request that reasonable accommodation to work from home under the ADA. And if it's, I can't go to work because I've got childcare, there might be some existing protections in the law that allow you to stay at home for some period of time and still get paid, or be at home and not be paid, but at least have your job protected for a period of time.
And do you think if employers are doing everything that has been requested of them in terms of providing a safe work environment and someone gets sick at work, is there a claim?
I'll do the same answer. It depends. That's a tough question. I really think that it will really depend on the facts of that specific scenario. In your hypothetical, the employer has taken every possible precaution and there's no way to trace it back to the employer. The employer is tested, the employer had no, and I mean, the other harder part of that question is also, it's hard as I understand the news and what I'm learning, and I'm learning more every day, but it is very hard to be able to say, this is where you picked up the virus.
Unless right? So every person on my team suddenly is sick, right? Then it's like, okay, there seems to be a common denominator here.
Right.
And, like I read about a girl who was in a bar, she said all 15 of her friends got sick in Florida. I was like, whoa, okay. And they were in one bar. So it's like, pretty obvious where it came from.
Sure. But then there will be, in terms of what that fight will look like, I'm sure there's going to be an argument about, were they 6 feet apart, and were there enough precautions there for them to be 6 feet apart? And by choosing to go into the bar and be with a group of 15, were they already sort of violating an order in terms of how many people you can socially gather with? And was the bar violating an order about how closely they had the stools?
There's no rules in Florida. This is not California.
Right.
You want to have a beach party? That's where you go.
Go for it. Yeah.
So what about, are you seeing an uptick in, discrimination in terms of, I think it's not unusual that people are going to have to cut. Unfortunately, they're going to have to cut people in some cases. So are they cutting the same kind of people across the board, or, are you seeing an uptick?
Yes. Yes, and yes. So one of the biggest things that I have been watching, just given my own personal interest as well as what I do for a living, is women are being really hit by COVID-19 in so many different ways, whether it's additional caretaking responsibilities, and in the employment context, it really is, you have women working in high rates at many of these essential occupations. They make up something like 75% of hospital workers, 93% of childcare workers, 63% of fast food and counter workers. And that means they're getting hit at work, they're getting hit in terms of the childcare needs that are obviously happening in their own community since their children's schools are closed. I think of those percentages, I think I had read somewhere that mothers with children under the age of 18 are something like 16 or 17% of all workers, and they're 35% of registered nurses, 28% of childcare workers. So those categories of occupations that are getting hit pretty hard right now are disproportionately women, mothers, women of color particularly. And so you see this play out in a lot of different ways. And in terms of what I'm seeing in our practice is, it's hard to go from having no cases involving pregnant women to all of a sudden I have 4. That's where there's like a potential pregnancy discrimination claim. That causes me concern. I mean, I know there's layoffs and I know there's lots of reasons for them, but that's an uptick for sure. And while we haven't had any cases relating to this, there had been reports of an uptick in harassment at work, in the workplace on the basis of national origin. Sort of beginning of the pandemic, there was an uptick in national origin and race discrimination experienced by Asian Americans, given some of the rhetoric around the virus. There is going to be, I'm sure, cases involving the ADEA, which protects older workers, and how workplaces are making decisions on who to keep, who not to keep, who is getting accommodations and who isn't, and all of that. So yes, there is going to be I find it hard, and maybe given just what I have done for the entirety of my career, I think it will inevitably play a role. There are biases, both implicit and explicit, in the workplace that are going to play out as employers are struggling with the economics of the situation, the human component of it, and people's reactions to everything. So
in your line of work, it's a little bit of a sensitive topic, but I think it's an important one for people to understand. It seems like you're serving largely disadvantaged people. So is the way the economics work, is it that you work on contingency and then the employer covers your fee in the end? Or does someone need to be able to afford really good legal counsel in order to get representation?
I think so every practice is going to be different. There's a host of really fantastic service providers that aren't a completely private model. Like I said, I worked for 10 years at the EEOC, and people would file charges there. And then we in legal unit would actually litigate a small percentage of those cases, but still we would take them to court on behalf of an aggrieved employee. There are places like Legal Aid at Work that does fantastic work in Northern California that would be able to assist people. And then even in our own practice, myself and my law partner are pretty passionate advocates for employee rights. And so we're running a practice, and so we've got to, feed ourselves, but at the same rate, there is something that sort of motivates us to ensure that there is a way to ensure that people have the rights that they need. So we do our work in a variety of ways. We do contingency work, we do hourly work sometimes if that's sort of the better model for a situation. And oftentimes we'll do, have some sort of hourly cap on our work and then move to a contingency model so that there is a balance in the way that the person who's coming to us can make the ultimate decision about what they want to do, whether they want to accept that severance package as offered to them, or if they want to take more. So we try really hard within our own practice to make sure that our paramount concern is assisting the employee in getting to the goal that they want to get to. And sometimes that means that a contingency is the best way to go. And it's generally a contingency of whatever they are achieving out of that resolution. And, you know, that resolution sometimes happens quickly, and sometimes that resolution takes a long time, or it comes after litigation or comes down the road. So really it's a mixed model of how we approach things, but there are plenty of organizations out there that do fantastic work for all, you know, people within a certain income level. But I would never, in our firm, we would never say we only serve a certain population of people, or we only serve high wage earners. We serve the gamut. I'm part of like the Time's Up Legal Defense Fund through the National Women's Law Center runs a legal referral network, and I, you know, take referrals from there as well. So it's important to me that we're providing good work for employees and trying to get fair resolutions for them at the end of the day.
Awesome. I love that about you. It's so important that we have people doing the work that you're doing.
Thank you.
Let's see. I think I covered most of what I have here. What did I forget? What should I be asking you?
I think we did a pretty good job of getting through stuff. I mean, you know, I certainly, like I said in the beginning, I certainly appreciate this conversation, because I think that while tricky, and, you know, it's easy to say, well, I'm an employer, so I don't want to talk to a plaintiff side employee lawyer about these tricky issues that could get me in trouble. I feel like that's the conversation that's worth having, because, you know, to the extent that people are trying to do the right thing is sometimes complicated and nuanced, and I understand that. And as long as the conversations are happening and we're trying to achieve that, I think that's an important goal for everybody to have in this moment and at all times.
Absolutely. So I will include your contact information, and for anyone who's made it this far, I'll put this also at the top. You know, feel free to contact me if you feel like you've been discriminated in any way. If you think that you're about to get fired, or you did get fired, and you feel like something was off or unfair, you know, she's definitely happy to consult with you, and then either point you in the right direction if she can't help you, or help you with your needs. So thank you so much for your time today. I really appreciate it.
Thank you, Ruth. It was good seeing you.
All right. Take care.
Take care.
Bye.